For this particular item, if the only way that the board can meet with an attorney is if we select one, if the whole board selects one of us to meet with an attorney, that's the way the current bylaw reads. However, temporarily that's fine, but I would like to, in the future, think about changing the bylaw to where we as the board can meet with an attorney should we need to. I'm just thinking about the future. We should have the freedom to meet with an attorney about various concerns that we may have.
So this would, can you summarize like what this would allow for?
With the currently the way the bylaw, and correct me if I'm wrong, Dr. Jimenez, currently with this bylaw, the board would have to select one representative to speak on behalf of the board and meet with an attorney.
Well, thank you, Ms. Quinones, for the comment. So the last sentence that you see here, which basically states what you just mentioned, that the board also may authorize a specific member to confer with legal counsel on behalf of the board. And so that is currently in our board bylaw as a possibility if the board were to authorize a specific member to confer with the board. But I really do believe we need our legal counsel to be able to just provide additional insights with respect to the word confer, because there are issues with respect to certain board members or a board member who's had that authorization, or various board members who may have the authorization to potentially get into a gray area. And I think that could be discussed. But I think that what I would like it for Mr. Castle to be able to explain what confer means with respect to our current board bylaw. Mr. Castle?
Madam President and members of the board, I view the term confer as brief, informal, if you will, not a lengthy discussion about a topic. I think if there is a lengthy discussion or a need for a response, then we would generally provide that through a written memorandum for the entire board to be able to see and view. But brief conferring with one of the board members would be just that, and it would be quick advice. For example, the matter that we dealt with earlier that I spoke about, the conflict, it could have occurred under a brief conference, if you will, with myself and a board member who believed they may have had a conflict, and we could have resolved it through a quick conversation, and we could have provided some direction. Not that what occurred was wrong. I want to be clear about that. Out of an abundance of caution, that's why it was done. But in some instances, it could have been fixed or dealt with differently, rather.
And so when I hear confer and what I hear side conversations, and in the past, I was concerned as a board member of other board members having side conversations with our lawyers, like someone saying in closed session, oh no, we'll finish this conversation later with the lawyer. That's conferring. And so I feel like people have been doing this already. And so, but it wasn't allowed. And so I think those are some of the concerns. I have that concern. And so I'm glad we're being more organized about this.
I think I'm more concerned about, as you're aware, as to what happened to our former superintendent and some of the actions that took place. We cannot say it in detail, but if the board had more of an ability to speak to legal counsel about concerns we had about a superintendent, a cabinet member, and so on, perhaps we could have avoided what occurred with the former superintendent. So what would be your recommendation as far as changing this bylaw so that the board has that ability to speak with legal counsel about concerns that we may have with, for example, the former superintendent, what she did?
That's a very good question. I am aware of one city in the area that has a provision about their board members contacting legal counsel. And as I recall the provision, it's been several years since I've looked at it, but it limited those elected officials from contacting the attorney unless it was something dealing with a conflict of interest. I served many years in that capacity as their attorney, many, many years. I think I was possibly the longest serving attorney they've ever had. I often got calls from those electeds, and it wasn't always about a conflict of interest. But I thought in the interest of serving the institution, it was important that I respond. And I get the provisions here and your bylaws limitations, and I'm not suggesting any of you violate your bylaws. I think it's important that all of you follow them, and it's important that as the superintendent does, Dr. Jiménez does, or your attorneys do. I think that that's important. But should one of you call me and say, hey, I got this issue. You're not calling me just to stir the proverbial pot. You're calling me for a reason. And I'm going to try to be as responsive as possible, recognizing the limitations and recognizing that I'm not going to produce a treatise on the issue you've raised, but I'm going to try to be responsive and try to get back to you and try to address the concerns that you raised. And also, 9 times out of 10, 9.9 times out of 10, I'm also going to tell your superintendent. I'm going to be very open, transparent, as you all just finished talking about. And I'm going to tell Dr. Jiménez, this is an issue that's been raised. Now, your example, I may not be able to do that, Ms. Quiñones, but certainly.
But that's precisely the concern.
Right.
If you have a really bad superintendent like we did, that did unethical,
Allegedly.
I have to, okay.
Allegedly.
Yeah, we want to be careful.
Okay, we got to be careful.
I'm here for that.
Yes, thank you.
You're welcome.
If we had a superintendent that was doing a lot of bad things, and we would bring that to your attention, and then you would go and tell that superintendent that was
Well,
doing those things.
In that instance, I would exercise discretion. I mean, at some point, yes, you have to, as legal counsel, you have to exercise that kind of discretion, and you deal with those issues on a different level.
Yeah, because
but-
I think right now, some of us feel like we don't have that freedom to properly represent
Mhm.
our board because we feel limited
Right.
as to seeking legal
Just-
advice. I mean, I do. I don't know about
I
you.
just want to also mention that the challenges you have when everybody starts calling the lawyers bills go like this.
Right.
And that's something that, we all want to be cognizant of. You often all talk about the direction of money for the students.
I think what is difficult is if the 5 board members know that there is something going on, we cannot meet because we would be violating the Brown Act, but we would know that there is something wrong. And then we're not able to really seek legal advice. So you're kind of tight. So how can you properly protect the district?
Again, as I mentioned, my ethical obligations are to the institution, to the district itself. And I'm not going to engage in violating bylaws, but if there's something that's so critically important and you're going to call and you're going to raise issue with it, then I'm going to figure out how to properly respond and to ensure that the district is ultimately protected. It's about limiting the liabilities to the district and trying to avoid increasing costs. But by the same token, I have been in the instance where I've had to meet with clients where the electeds have met just with me and the administrators are not present.
Okay, but
we go forward.
that's not something that we can do under the current bylaw.
You can do that under the Brown Act.
But, under our bylaw, we can do it,
Right,
right?
I understand that, I understand.
But that, we can change that so that we're able to do that, right?
Yeah, I think limiting the conferring process is important. Otherwise, you may have attorneys that just ratchet the time and the costs.
I think Mr. Delatorre has something.
Thank you, Ms. Jimenez. Mr. De La Torre?
If you don't mind, thank you. I guess I'm looking at protocol. I know when the superintendent needs advice, legal usually supports our superintendent and Scavin is on dealing with the issue. I guess my concern is when board members, we get a lot of information and we have a concern. I think it's important that we have a designee. I like to think the president, that they can meet with legal and support us before he gets out there. But it's just not happening. I know I've had issues that I have brought up to the board president, and it went on deaf ears. As of now, I haven't heard anything. And so my concern is there a way that we can meet with legal, or we meaning either if I'm the designee or whoever it might be, and just seek advice, how to proceed with these allegations? Because it's not happening right now. I just feel like as a board, you're on your own unless.
Well, I think what you're trying to do through this bylaw is to allow that to happen. So the board would have to designate one of you, and then that one individual would have to confer. We need to be respectful, of course, as you all well know. If, let's say, it's you and another board member who have raised this issue with the president, then the president raises me, and the president happens to say, I'm very concerned about this, and two other board members are concerned. Now we've had collective concurrence and arguably a Brown Act violation. So you have to be careful how that all works. I think that during the time we've had the opportunity to serve the district, we've developed a relationship with Dr. Jiménez where we're able to communicate and talk about things. And so, and respectful as well of our time and costs to the district. So
Mr. Clark, you have a comment?
Thank you, Madam President. The rules already allow us to go ahead and do this. If in fact there's an issue and it involves the superintendent, we just excuse the superintendent. We've done that before. And what you do is you put it on to the closed session item and you say, here, we're only going to talk about this. It's not, free for all, right? And at that point, you said you can be excused under those circumstances. And we've done it before, right? So that's how you go ahead and do that. With respect to if you want counsel to give an opinion on something, right? Put it on the agenda, right? We'll do and close. We vote for it, right? Three of us, okay, let's get a legal opinion. Then you have that. What you don't want is you don't want 5 school board members calling up counsel, okay? That is a very, very not only dangerous, right? But I also would tell you that is clearly unlawful. And the reason why it's unlawful is because not 1, not 2, at least 3 areas of our bylaws state that a board member cannot engage in either administrative or management functions. And that's what's going to happen, right? It's going to bleed into something like this. And all of a sudden, the really not a very good scenario is we have board members that have a conflict and a dispute. And then all of a sudden you're going back and forth on this thing. And again, the way to handle that is we just go internally. And if we decide we want a designee, then we as three or the board, remember, our bylaws state that a board member doesn't act alone. It actually adds with respect to a majority. So this is already into this thing. Now, I'll add one other point is that I've had discussions with CSB before about, these type of things. And, their concern is they actually don't like it. The reason why they don't like it is because the time now is different than the time before, right? All you gotta do is take a look at some of the other districts, on notification or that. I'm not saying it's good or bad. Don't want to get embroiled in anything like that, but there are some hard thoughts with respect to that, right? And so they don't like that because they're concerned, even under these circumstances, that you allow a loophole so that all of a sudden somebody comes in and then they again are engaging in management or administrative function. I will tell you, in my experience, I have seen board members out in public at events telling people what to do. Literally. Say, hey, you got to do this, you just can't do that. And when I see that, I'm so disappointed, but I don't want to confront the board member because then I might cause a scene, right? Let's steer away from that. We do have a mechanism with respect to that, and it's exercised before. I'm confident that we can go forward with it like that. And again, as an aside, I think CSBA is going to tighten this thing up and say, we're going to revise the model and we're not going to allow any of this thing to happen. Thank you very much, Madam President. I'll go back to you.
So I'm going to contribute and then toss it back to you. I'm really concerned about, I feel like the lawyers are the backbone to all the decisions that are being made. And lawyers have been weaponized in our district against our community. It's really concerning. And there seems to be a conflict of interest because the lawyer seems to be representing the district and our superintendent. And the board, our job is to make sure there's checks and balances in the district with the superintendent. And so when the lawyer is representing both parties, that's a conflict of interest. We need to have our own representation as a board because there will be conflicting interests. So if I think that our district did something illegal, I want accountability. Now, I don't want someone saying, hey, how do we sweep this under the rug because I don't want liability. No, there needs to be accountability. So how can we go about making sure that the lawyers are our lawyers versus the superintendent's lawyers?
For the record, I want to be clear. I'm the district's attorney. I work for the district. I don't work for Dr. Jiménez. I work with Dr. Jiménez. And if there are things that come up where I need to correct him, and that hasn't happened, but if there was, I would certainly do that, and I've done that in the past. As far as the board, ultimately, we serve at your pleasure. If you wanted to get rid of me right here, right now, well, you really can't because it's not on the agenda, but if you did, if it was, you could, hypothetically speaking, Madam President, you could dismiss me right here, right now. So I work for the district. You all effectively work for the district. You have that fiduciary obligation to work for the district. So whatever we do, essentially we need to be walking in parallel with one another. And how do you ultimately accomplish that? With all due respect, Madam President, you hire good lawyers. And I'm not in any way, shape, or form demeaning the attorneys that work for this district, but you hire good lawyers. And that's how I think you ensure the services they're providing is for the district and not for any one individual.
Perfect. Yeah, not for any one individual. That is a very important point. How can we go about designating this person for this policy?
Thank you. So basically, part of the discussion today was to hear the board's interests, whether there was enough consensus on the board just by what you are sharing today to be able to bring back an agenda item which would authorize a specific member to confer with legal counsel as stated in our bylaws. So we would have to bring it back as a separate agenda item to actually select somebody. And so that would be done in a following board meeting if there was enough of a conversation today leading towards that area.
Man,
Thank you, Dr. Jimenez. Mr. Quack?
thank you, Madam President. So what I'll tell you is, the first thing you learn on the first day of corporations law is that a lawyer represents the entity, does not represent any individual, period. And that's always the case. So in this situation, any legal counsel that represents the school district represents the school district, does not represent any individual, whether it's a superintendent, individual board member, or anybody else. The other thing I'll tell you is that every lawyer is governed by the ethical canons of the State Bar Association. And the State Bar Association also states that an attorney that represents an entity, whether it's a partnership, whether it's a limited liability company, whether it's a general partnership, whatever a corporation, they represent the entity. They don't represent anybody else. So that's basic. The other thing is that